A very good morning, listeners. I'm Dushi, your host from Morning Coast, and today I have a very special interview for you. I have with me Sir Joshua Sheqi. He is an advocate at District Court Kohima as well as in the Guwahati High Court Kohima Bench. Thank you so much, sir, for being with us.
It's a pleasure to be with you this morning.
Well, sir, today I want to talk about the criminal justice system in the state of Nagaland. There has been a lot of talks. In fact, a lot of people don't really have faith in the criminal justice system in the state of Nagaland. So what is your take on that? Can you kindly share to all our listeners?
In fact, I'm a defense lawyer, so sometimes it's a little tricky to be discussing on this, but for the larger welfare of the people in general, I feel that, there is a strong requirement for criminal justice system to be stronger than what it is today. If you look at the investigation and all, there are lots of investigation loopholes that takes place in the investigation by the police and all. And many a times people blame the police. But I feel that the police are not to be blamed because the process of modernization also has taken place. Even then, in many areas, of course, I'm not undermining the police, but I feel that they need to be more equipped. And for this, if you look at the criminal justice system, as a defense lawyer, some people have walked up to me and they have asked me, are you such a good lawyer or are you such a good liar that you've been able to defend the person, some murderers or any so-called branded extortionists and all? People tend to ask us questions which makes us uncomfortable at times. So I've also been giving a thought on this, on how we can improve the system, make the job of the defense lawyer like me also harder. At the same time, a more competent investigation process. For instance, in the course of investigation, sometimes I tell the people, it's not only with the police. For instance, a murder has taken place. After the murder has taken place, you have to take the dead body also for post-mortem as well, to see the real cause of death. Nagas have this tendency of, it's okay, no problem. And then they would say, we'll take care of the dead body, don't make it your problem. Not knowing that they are losing out a lot of important points in the course of trial that would begin based on the evidences that is collected. And so, definitely the person who is supposed to receive the punishment he deserves or she deserves, it gets reduced or they go scot-free because of the loopholes created from the beginning itself. And for this, I have a feeling that we should have a prosecution directorate. If you look at the way the prosecutors are working in a court today, they have to guide the police also by giving them direction on, this is not done, that is not done. You need to reinvestigate in this area and all. But they are overburdened in the courts. So definitely a police who is not a practicing lawyer or part of the prosecution who is appearing in the court every day, they will have confusions. And they can be properly guided by the prosecution directorate. But that is not happening. I feel it is a very opportune moment for me to say this and appeal even to the state government to see the importance of getting a prosecution directorate where there will be full-time prosecutors with experience in the practice in criminal jurisprudence. They will be the right person to be able to guide the police, to give them directions on how to investigate the matter. For instance, in some corruption cases also what happens is, because of the loopholes of investigation, or for that matter any criminal case, there are lots of loopholes in the investigation. As a defense lawyer, it is not my duty to say my client did not do that, or my client did this or did that. It is my job to tell the prosecution, or to tell the court, has the prosecution been able to prove this? If they cannot prove it, ultimately what happens is the benefit goes to the accused person. Because if you look at the criminal jurisprudence in a country like France, the onus to prove the innocence of the accused lies with the accused person. But we follow the system that the US is following in Britain and then some other countries. Our system is the onus of proof. It lies with the prosecution. So once the onus to prove the guilt of the accused person lies with the prosecution, Definitely, the benefit of doubt goes to the accused person. A lawyer need not lie. A lawyer only need to tell the prosecution to prove before the court. If the same is not proved, what happens? Benefit directly goes to the accused person. As a practicing lawyer, sometimes, of course, there are times when your conscience is also pricked. But to avoid that, no, this is strictly for the state of Nagaland, as you have mentioned. So what is at the back of the mind of lawyers like us who are Christians is sometimes we give an option to the accused person or client. Right. If you say this, that will happen to you. If you say that, this will happen to you. We give a choice to the accused person to make a choice on whether he will say this or say that. We don't necessarily tell the accused person, you must say this. It's not our job. It's a matter of a conscience also. And that's how, we maintain that balance to be lawyers. No?
Okay, so well, according to what you have said, I assume that the fact that a lot of criminals are roaming free in the society is because, to some extent, largely because of the incompetency of the prosecution and the investigation.
Of course, I would not directly say the prosecution, but I would say the process of investigation. Because a prosecutor, however good he or she is, cannot defend the case of the prosecution based on the faulty investigation. It becomes difficult. A lot of procedures, like sometimes you say that you got a gun in my hand and there is no independent witness. Right. Of course, this is not to get into the strict technicalities, but if you look at Section 100 of the CRPC, the Section 100 says the procedure on how to make arrests and all, where there should be public independent witnesses also, many a times it is not there. So how do you prove your case to say that I was holding a gun? Now you have to be very careful in taking care of that gun also. You know what happens, including the Indian Army, they would just mess up the guns and all and then they bring it. So where's the question of saying that I was holding a gun? You have to send the gun to forensic science laboratory tests, and there can be two types of tests. One is fingerprint. And if you have messed up with my gun and then a fingerprint test is taken, what will happen? You will become the culprit yourself, not me. So, at times it's important even to discuss these things, hard talk, face to face, and without any reservation, because it's for the larger good of the society. And a lot of loopholes, which cannot be explained in detail in this very short talk, it happens. And that is the result of what we plant or what we cultivate.
So what do you think is the most important problem that lies in the criminal justice system?
Well, as I've mentioned earlier, what I feel is a prosecution directorate should be given a serious thought by the state. Definitely, I don't mean to say that innocent people should be convicted. Sometimes, due to circumstances, even though you're not directly involved, or you may not be the actual person who has done things, you may get convicted. And it is both against the accused persons as well as in favor of certain accused persons, depending on the nature of each case. So for the larger good, a proper and then competent investigation, it can happen only after having a proper directorate for the prosecution separate. Because as I've mentioned earlier, the public prosecutors are overburdened, and that the same is not being given serious thought by the state government, which I feel it's a very sad development. And on a random basis, they want to continue working. And in that case, definitely even the police, not just the public prosecutors, but the police are also overburdened. I don't think it's because of the number of police personnel, but it's because of not being able to, divide them and then put them into specific jobs and randomly making use of their service. Expert police who are good in investigation, they can be trained further and then they can join the prosecution directorate. And if their job is only to investigate and then they are investigating one thing, all of a sudden they get a call, you must go there, you must go there. What happens? There's a lot of, that's why the case of the prosecution, in many cases, it gets disarrayed. There is no consistency because it's scattered. It's by the system that we are maintaining, that the result is showing. So ultimately, I don't say it is the fault of the prosecution or the police, but it's because the system is not put in place. And to put the system in place, prosecution directorate is a must.
All right. So, in the state of Nagaland, with regard to the criminal cases, what type of cases comes usually to the court?
Well, the most common of all is extortion and theft. These are the, especially theft, it falls under the petty category. And as you see, many a times the public cooperation is also a must. But then what we see is, I think the public are also not doing their job as required by law. For instance, if you go by the procedure of law under the CRPC, when asked for service, when asked, a public or any member of the society is expected to assist the police in the investigation, which is not happening. And then, a lot of cases, it gets decided by the customary courts and all without jurisdiction. They are empowered with only the power of second-class magistrate if we go by law. But that is not happening, and then people's faith is also dwindling, partly because of people's fault also, and then the lack of, the institution of the prosecution directorate, that is also not happening. All these things being put together, I feel that it is the confidence of the people which is eroding can also be built up.
So, like you've mentioned customary laws, I just want to quickly ask one question. Like, there's clearly a conflict between customary laws and our criminal justice system, that is our statutory laws and all.
Yes.
So, strictly with regard to criminal justice system, how can we, balance this two?
In fact, if the customary institutions are as pure as it was before, then Article 371A is protecting the customary usages, the practices that we have been having since time immemorial. But what we see today, of course, we are not to discuss about the details of customary laws, but there is a lot of inconsistency, and there is a lot of influence depending on haves and have-nots, which is unfortunate. So with this kind of system, we cannot maintain the purity of the customary laws. The other problem with the customary laws is also that I think all the tribes should have a proper sitting together and somehow bring up some kind of codified customary law. If not, you're from different village, I'm from different village. My criminal justice system in my village may not be fully applicable to yours, although there will be definitely a lot of similarities. We just try to, demand some kind of, or make claims about a uniqueness. And that also promotes tribalism. So in the process, even if it is almost similar, we tend to disagree with the others. So one village cannot decide a case in another village. That thing is happening. So our people, especially in the ho-hos and all, also need to give a serious thought. If not, the importance of customary law may have relevance only to that particular village. And in that particular village or institution or area also, what is happening is because of certain external and then extraneous considerations of have and have-nots being influencing the customary institution decisions also. I'm not saying all, but many a times that is the picture. So with this kind of things, the importance of customary institution is eroding. And the image of customary institution is also, to a large extent, it's compromised. So to give weightage to the protection that we have under Article 371A, and to again make use and revive the stronger use of customary laws, we need to have a codified law. And at the same time, of course, to conclude my sentence on this issue, customary institutions also, they have to keep one thing in mind. Customs are something that has been in continuous use for so many years and generations, and it becomes a convention that, yes, this is ours. Later on, it becomes custom. So things that, even among the custom that we use in the past, things that is against the present modern laws, international conventions, making declaration that this is the reasonable way of dealing with this. If it is found to be against the Article 14, 16, 19, 21 and all of the Constitution, until and unless it is in tune with such modern laws, then that customary law itself has become redundant. It cannot be used. And it is also in the process of improvement to deal with the present situation. In some cases, we stick to the old unusable customary laws. In some cases, the good ones also we bend it for our convenience. With this kind of happenings, customary institution, with the protection of Article 371A also will lose its value of being used in the present generation. So it is an appeal to the tribal bodies and all also to give a serious thought on this. We are not undermining the customary institutions. It's the purity of the institution which has to be revived and maintained.
Well, sir, it was a pleasure sitting with you and discussing all those relevant issues. I wish we had more time, but on a final note, would you suggest youngsters to study law? And if yes, what is your message to them?
Of course, I would always suggest people to study law, but of course, the two things that a person who wants to study law must possess is he or she must have a good command over the language. That is the first quality that is necessary to be considered as a ready-made lawyer. Mm-hmm. Second quality is one must be willing to work overnight without sleeping, also hard work, extreme hard work. Even if you do not have much of the first quality of having good command over the language, drafting skills and all, if you are willing to burn your midnight lamps and then is willing to go extra mile to work extremely hard, then this profession is for you. But if you don't have these two qualities, it's better that you not waste your time in trying to study law, because this profession does not care whether you're from a rich family or poor family. This profession is only for people who really want to do it and has the determination to do so.